Hi, everyone, and welcome to our latest program. I am Nelda Golden, Vice President of Southwest Jewish Congress, and we are delighted to have you with us this evening. SWJC is a local nonprofit membership organization that is open to all who welcome diversity and want to build bridges throughout the community. We provide complimentary educational programs, and we honor those who contribute to the advancement of our society, culture, and lives. Save the date for our Texas-sized event, which is scheduled for Thursday, May 12th. We are accepting nominations for women, men, and young adults that have been diligent in the pursuit of positive social change and who, as role models, have made an impact on our communities. These inspiring women and men of action advocate for inclusiveness in our society and support positions consistent with the missions of SWJC. You may download a nomination form at our website, swjc.org. Our upcoming programs can include, as you've seen, perhaps if you were on a few minutes earlier, our next program will be From Conviction to Freedom on November 9th. The following program will be on Texas and Israel working together. Tonight's program is being recorded, and a link will be mailed to you when it is ready for viewing. For information on upcoming programming or any other information that you would like, incidentally, you can also receive recorded previous programs. Just visit the website at, as I said, swjc.org. Now I want you to follow these instructions for the question and answer period that will be available to you at the end of the program for approximately 10 minutes. Type your questions on your screen in either the Q&A area that you can see or in chat. And then these will be read to our participants during that Q&A period. Now it's my pleasure to introduce you to our host tonight. Our second host will be introduced by Judge Lynn. Judge Lynn is a graduate of the University of Virginia, summa cum laude. After she received her degree, she attended law school at SMU and was hooded by her husband, Mike, at her graduation, position number 1. She is was brought to the position she has by President Bill Clinton. And today is recognized as one of the most distinguished judges in the United States. She has received many awards, and currently she has 2 prominent legal organizations that are named for her. On the personal side, she is married to Mike, as I mentioned. She has 2 daughters, Tara and Whitney, and 3 grandchildren, Riley, Blake, and Shepard. May I present my daughter, Judge Barbara Lynn.
Thanks, Mom. It's really an honor to be here, and particularly to be with my mom, who, as everyone who knows me knows, I so greatly admire and love dearly. It is my great pleasure to introduce as my co-speaker, Alex Abdo. Alex was one of my law clerks many years ago. I just love the guy. I'm going to begin my introduction by saying that. Every time I go to New York, he and I get together. We have been known to take a pedicab across town for a good deli sandwich. Alex is the inaugural litigation director of the Knight First Amendment Institute at Columbia University. In that capacity, Alex has been involved in nearly all of the institution's litigation, and including in that litigation is some very interesting litigation relating to President Trump and his blocking of critics from his Twitter account, which is quite relevant to the issues that we are discussing this evening. Before Alex joined the Knight First Amendment Institute, he worked for 8 years at the American Civil Liberties Union, where he litigated cases relating to NSA surveillance, encryption, anonymous speech online, government transparency, and the treatment of detainees in US custody after 9/11. Alex is a graduate of Yale College and Harvard Law School. After clerking for me, he clerked for the Honorable Rosemary Barquette, who was a judge at that time on the United States Circuit Court for the 11th Circuit Court of Appeals. Alex, say hello to our audience.
So nice to be here, Judge. Such an honor to be in conversation with you.
Ditto, Alex. Well, let's get right to it. This is a topic that everyone thinks about today. So much of our discourse today is now online. We're not really in the public square, even before COVID, where we're all meeting together. Most communications between us are online these days. And courts are increasingly being called upon to decide how established doctrines relating to speech apply in these new digital spaces. So tonight, we're going to explore, as time permits, a number of the questions that these new techniques of communication have raised with respect to the First Amendment and free speech more generally. I'm going to start with a very brief overview of the free speech clause of the First Amendment. Then Alex will discuss some of the exceptions to the First Amendment, and then we'll talk about some questions that courts and commentators have focused on in the last few years, and then we will take some questions from the audience. Now, you should feel free to post your questions as they occur to you. We'll take a look at those as they come in, and we may be able to work those into our discussion before we get to the Q&A session. So let me begin with discussion of the First Amendment. The First Amendment with respect to speech is really very simple. It's only about 10 words. It says, Congress shall make no law abridging the freedom of speech. That's all it says. It doesn't cover many of the things that we are going to be discussing tonight in any detail at all. And it's mainly been courts that have had to fill in what that constitutional mandate means. Now, note, it applies to Congress making laws, but the First Amendment applies to the states through the 14th Amendment. We're not going to discuss how that actually works in practice, except to just tell you that this applies to Congress as well as to the states. But it doesn't cover private persons, private companies, what can be said at work, what is prohibited at work. It doesn't require competing views, such as the appalling notion that an opposing viewpoint must be taught in school about the Holocaust, although federal laws may require equal time for broadcast of some political candidates who are given free media time. That's not a subject for us this evening, but that is not technically covered by the First Amendment either. But the First Amendment is not absolute. It doesn't cover all speech under all circumstances. Alex, tell us about exceptions to the First Amendment.
Yeah, absolutely. And one of the surprising things I think that a lot of people learn when they first come to the First Amendment is exactly what you said, Judge Lynn, which is that these dozen or so words of the text of the amendment don't really answer any of the interesting questions that we grapple with today about what the amendment is meant to protect and what protection it actually affords to different things. And over time, the courts have come up with a list of exceptions to the First Amendment, things that courts have determined for one reason or another will not be considered to be the freedom of speech within the meaning of the First Amendment. And the classic list is actually relatively short. People generally cite obscenity, defamation, fighting words, and true threats. This is the kind of classic list of what the First Amendment doesn't protect. One important thing to note that is not on that list is lies, at least not lies generally. Defamation is a particular kind of lie. It's a lie about a person that happens to defame them, in the words of the law, that lowers them in the estimation of their community. But lies, as a general matter, have never been held to be unprotected speech by the Supreme Court. And in fact, in many contexts, lies are protected, and it may be relevant to our conversation tonight. So I'll just let you know about a relatively recent Supreme Court case called Alvarez came out a few years ago that addressed the constitutionality of a statute called the Stolen Valor Act, which made it a crime to falsely claim that you had been awarded certain congressional awards, including the Congressional Medal of Freedom. And an individual had been prosecuted under that statute, and his case went all the way to the Supreme Court. And the Supreme Court held that the statute was unconstitutional insofar as it criminalized falsely claiming to have won the Congressional Medal of Freedom. It's maybe surprising to some people to learn that, but generally speaking, lies are protected by the First Amendment. And another category you would have noticed is not on that list, which is often a part of contemporary discourse around free speech, is hate speech. The Supreme Court has never held that hate speech is unprotected. And this is actually, interestingly, in contrast to a number of other democratic nations around the world that do criminalize or otherwise prohibit various categories of hate speech, and it has created this understanding of US free speech law that we are generally understood to be the most protective of free speech around the world. And there's an interesting and reasonable debate to be had about whether a democracy needs to be as protective of free speech as we are, but nevertheless, that is our tradition. That is the doctrine and interpretation of the First Amendment that we have, and it has led to interesting and fascinating debates in this country. I'll stop there.
Alex, let me go back for just a moment. It may be that the reason that we see private companies getting involved with hate speech and regulation of it is because there's a vacuum there where the government is not doing that. In other countries, particularly in countries such as Germany and Japan, but particularly in Germany, the government regulates speech. But in this country, we do not. And that's why you might see Facebook, Twitter, et cetera, stepping in to regulate that kind of speech that would otherwise be unregulated. Is that fair?
I think that's exactly right. And I think the idea is that we disable the government from regulating speech, but one consequence of that is we enable private actors to regulate speech. We expect private actors to regulate speech in any number of ways, through social shaming, through private coercion. Right? You can be generally, in most states, you can be fired from your job because of your political views if it's a private employer. There's some states that provide some protections against that, but generally speaking, that's perfectly constitutional. That's the flip side of disabling the government from regulating speech.
In fact, that happened in Charlottesville. It happened with respect to the January 6th demonstrations. Employers saw their employees on media coverage and fired them all. And that's perfectly legitimate as far as free speech issues go, not necessarily employment contract law.
Yeah, that's right. The First Amendment is not implicated. There's always a separate conversation in this country about, even if the First Amendment allows it, should we as a country condone it, or should we promote greater tolerance of viewpoints that differ from our own by tolerating differing viewpoints in the workplace? And people think of that generally as a broader free speech ethos that is divorced from the First Amendment. And that, that's a question of cultural norms and expectations that people set individually, but is not determined at all by the First Amendment.
Right. And let me make one point that I want to clarify. What Alex said is precisely correct. You can make false statements publicly, and that's not a violation of the First Amendment. But there may be other ramifications to a false statement. For example, the person who was prosecuted under the Stolen Valor Act, if he were raising money based upon his having received the Congressional Medal of Honor, that might be prosecuted as a fraud claim. So we're limiting our comments here to the First Amendment. Generally, there is very, very broad protections under the First Amendment in the United States. As Alex said, probably the broadest in the world. Now, Alex, one of the questions that we've seen litigated recently, I alluded to in my introduction of you, and that has to do with politicians who are using social media to engage with their constituents. This used to be something that never happened, and now this happens all the time. Politicians count their Twitter followers as a badge of honor. But sometimes they then block their critics from their social media accounts. I know you have been particularly involved in litigation relating to that. Can you tell us a little bit about this phenomenon, how it has been litigated, and how it's come out?
Absolutely. Social media has now become, in many ways, the battleground of our elections. Campaigns are fought online, seemingly more than offline these days. Essentially every representative in the House and senator in Congress has a Twitter account and a Facebook account and probably a couple of other social media accounts that they use to reach out to their constituents. And as they've moved online, the question has been, in what way does the Constitution follow? Almost as soon as we saw politicians moving their official speech online, we saw the practice emerge of politicians from across the political spectrum blocking critics online, looking, for example, at a tweet of theirs and looking at the most popular comments, the ones that Twitter lists first. And if it's critical, blocking that account so that that comment does not appear there, and so that that Twitter user can no longer respond to the politician's tweets. And that practice was probably made most prominent by President Trump, mainly because of his unprecedented use of Twitter. He really modernized the use of social media by elected officials, but he was far from the only politician to block critics on Twitter. And in fact, the first lawsuit that was filed, that I know of anyway, against an elected official was not our suit against President Trump, but actually was a suit against a Democratic official in Loudoun County, Virginia, an official named Phyllis Randall, who had blocked an individual named Brian Davison from her Facebook account for posting a comment critical of her role in the Loudoun County Board of Supervisors. That case and then the suit that we filed against President Trump raised the question of whether it is constitutional under the First Amendment for politicians to do this, to block their critics on Twitter. And it really broke down into two questions. And let me start with one bit of background law, and then I'll say what those two questions are. The bit of background law is that there is a long recognized doctrine under the First Amendment that prohibits government officials from censoring speech in a public forum based on its viewpoint. And a public forum is essentially a place where individuals are free to talk. The classic public forums are the sidewalks and public parks, courthouse steps. These are the kind of classic public forums, but any other place that the government opens up for open public discussion is also a public forum. And the bedrock rule of the First Amendment, again, is that the government cannot block people, eject them from those fora based on their viewpoint, based on the viewpoints they express. And so the question for politicians who use social media is first, is their use of social media, does it create a public forum, a place in which members of the public are generally free to engage with the elected official or with other citizens? And if so, is it constitutional for the politicians to eject people from that forum on the basis of their viewpoint? And that is those are the two questions that our lawsuit against President Trump and then Brian Davison's lawsuit against Phyllis Randall, and we ended up actually representing him on appeal and litigating his case in the Fourth Circuit. But those are the questions that those two cases raised. When a politician moves online, is that a public forum? And in both cases, the courts answered yes. The Second Circuit and the Fourth Circuit both held that when a politician uses their account essentially as an extension of their office, when they use it in their official capacity as government employees, then they are bound by the First Amendment and may not block critics on the basis of their viewpoint. And so both courts held that the practice was unconstitutional, and in both cases, the courts essentially declared that the blocking practices had to end. In our case, President Trump unblocked his critics and others, and in Randall's case, the same happened.
Well, Alex, some public officials are arguing that they need to have this ability to block followers of their social media accounts so that the level of the conversation can be dignified, thoughtful, and respectful. I've made the mistake a few times of looking at comments about me when I'm in a trial, often by people who have never seen me or ever been in my trial. But for my own sanity, I've stopped reading those because generally there are many that are not at a respectful and thoughtful level of public discourse. So one can understand how politicians, well-intentioned, want to keep the conversation at a respectful level. How can they do that given the development of the law as you have described?
Well, I think the First Amendment leaves them a few options, but I'll say at the outset that the answer I'm going to give is not an antidote to the messiness of free speech. Free speech is messy, and it has been since the founding. Dissenting views are often characterized as undignified and as disrespectful and incongruous with thoughtful public discourse, but that has been the history of free speech in this country. And often that kind of speech is what motivates change or causes people to think. And often it is just, speech we'd all recognize to be unhelpful, maybe in low value, as courts sometimes say. That's my preface, is that this answer is not going to be an antidote to all of that. But I think the First Amendment does give elected officials and politicians some latitude to moderate the public forums around their social media accounts in the interest of decorum. So one thing they can do, and this is the obvious one, is they can block speech that is unprotected. Speech like true threats and obscenity and defamation, none of that is protected by the First Amendment, and so there's no issue with elected officials or politicians blocking it. Now that does not describe most of the speech they may want to block, because those are, at the end of the day, relatively narrow categories. So the greater power I think that the First Amendment gives officials is the power to enact reasonable, this is language from the case law, reasonable time, place, and manner restrictions. And so these are restrictions on the forum that are not tied to the content of speech, and mainly not tied to viewpoints expressed. And these rules have to be viewpoint neutral, and they have to be enforced neutrally. They can't be, you can't slip in viewpoint based restrictions and characterize them as viewpoint neutral when in fact they're not. So what might that include? Well, it could include, for example, limitation on the number of responses that somebody could send in response to a particular tweet to prevent any individual from hijacking the conversation. It might also include a topic limitation. A public forum, courts have often recognized the ability of the government to decide what the topic of conversation will be in a particular public forum. In the analog context, in the real world, before social media, this would have taken the form of a town hall meeting where the subject of debate is next year's budget. And if that's the conversation, the town is perfectly free to limit the conversation to next year's budget and not, for example, immigration enforcement or something else. And so long as those rules are enforced neutrally and are in fact not, subversive efforts to suppress viewpoint, then those are fine. And I think those go some distance toward, creating, establishing the kind of decorum you might want in a public forum. But again, they're not a perfect answer.
All right, well, let me go back to the point you made, Alex, that free speech is messy. I think that is an important concept for our audience to grapple with. In fact, I'll mention a case that many in our audience, I think, would find particularly interesting. I'm sure Alex learned it in law school, and so did I. It relates to the American Civil Liberties Union representing the Nazis who were marching in a suburb of Chicago. Obviously, what they were saying was horrendous, but the ACLU stood up for the concept of free speech. Hateful speech though it was, that's what the Constitution protects. Now, that wasn't in this context. And the problem with this context is that that was a localized march by a few people in Skokie, Illinois. It wasn't seen by most people in America. Probably the lawsuit gave it more publicity than it would have had otherwise. But today, hate speech is seen and read by millions and millions of people. Sometimes this kind of speech is on television. Sometimes it's just on the internet, but it takes off like a bullet. And once it's out, it's out. You can't put it back. There's grotesque misinformation on television, on the internet, sometimes from what were thought of as reliable media sources, often from unreliable media sources. So there's a concern generally about whether perhaps our Constitution is wrong in giving this kind of forum to what I'm going to be bold enough to call bad speech. Now, that's really beyond our topic today. Alex and I are not legislators. As long as the Constitution is there, I'm going to be enforcing it, and Alex is going to be arguing for it. But it's a reasonable conversation, whether given what we have today, and I suspect that our founders could not have envisioned the world, the number of people, and how easy it is to reach them with false information and hateful information. That's all troublesome. So I just want to lay that issue out there. It's beyond our discussion today, but it's certainly something that deserves attention. I'm not arguing for a new constitutional amendment, but I just want to lay the issue out. Alex, let's assume that you are correct, that the First Amendment limits the ability of public officials to block their followers. Now let's turn to the topic that I alluded to earlier, social media companies. They have, in a way, replaced, well, the government never was in this business, but now social media companies are in the business of deciding what speech is appropriate and what speech is inappropriate. Obviously, President Trump was blocked from certain social media platforms. Many of his followers thought that was wrong because that was the way that he communicated with them, and they didn't like it. So what are the limits of the ability of these social media companies to block different kinds of speech on their platforms? And what do you, as a prominent lawyer in the area of free speech, think about it?
Yeah, and this is the $1 million question of the day. And the answer to the first question is relatively easy. Right now, it is generally understood that the platforms have free reign to decide who can speak on their platforms and what they can say. They are private actors. They're not bound by the First Amendment in deciding who can be on the platform and what views can be expressed. And they would argue, and some courts have been asked to answer this question and have agreed, that the platforms themselves have a First Amendment right to decide what speech they want to allow on their platforms, and that the exercise of, that their decisions about what content to allow are themselves exercises of editorial judgment. That's what some courts have said. And as a result, the current status of at least the law as it's been litigated is that the courts have the platforms have free reign, and they actually have a separate statutory protection that immunizes them from liability.
Are you talking about Section 230, Alex?
Yes. Do you want to save that for a minute?
No, I want you to discuss it. I think it's very important. Probably everybody on this call has heard about Section 230, but I don't think many people know exactly what it does. So I think this is a good time for you to lay that out.
Yeah, great. So it's Section 230 of the Communications Decency Act, but often just called Section 230 or even just 230. And it's very famously 26 words long, and some people credit it for creating the internet as we now know it. And it does a very basic thing. It says that informational platforms online, but basically the platforms, internet websites that host other people's speech, cannot be held liable as the publishers of that third-party speech. So if you are, for example, an email provider, and somebody sends a defamatory email through your service, you can't be held liable for that defamation. And if you are Twitter or Facebook, and somebody posts something defamatory on your platform, then you cannot be held liable for that defamation. Now, the rule would have been different in the analog world. If the New York Times, for example, published an op-ed by an outside contributor that defamed somebody, that individual could sue not just the author of the piece, but also the New York Times. And that's actually what happened in the famous case of New York Times versus Sullivan, which was a suit against the New York Times, a defamation suit by a police official. But in the online world, now with Section 230, the platforms are immune. And that the theory behind that was that providing them immunity actually would give them an incentive to moderate. Because there were some court opinions that came out right before Section 230 was enacted that held as a general matter, if the platforms engage in some content moderation of what is said through their sites, then they become liable, because then they have taken editorial ownership over the content of what's on their platform, and so they become liable for what's on it. And that actually created the perverse incentive, at least as lawmakers at the time thought of it, of providing a very strong incentive for the platforms not to moderate, because as soon as they started to moderate, they would become liable. But if they kept their hands off, then they might not be liable, or at least they might not be liable unless they had reason to know about some particular defamatory speech. Yeah, and the idea behind Section 230 was, if we immunize the platforms entirely from liability for the speech of their users, then they will be able to moderate without having to worry about the risk of liability. And so we will have a plethora of rules that can be applied by private actors to decide what any individual online community looks like. And that's the status of current law. And there are efforts, there are arguments being made challenging some aspects of Section 230's protection. But that is where things currently stand. And I think, one of the really challenging questions for free speech advocates is this a desirable state of affairs for a small handful of companies to possess and exercise such extraordinary control over the speech environment, to decide what can be said and whether certain people will be heard? And I think, not surprising, a lot of free speech advocates, myself included, are actually troubled by that state of affairs. The First Amendment at a very general level reflects a discomfort with centralized control over speech. In the case of the First Amendment, the government, but more basically, the idea, discomfort with the idea that any one person or small group of people will be able to decide what can be said in this country. Because whenever a small group has that power, free speech suffers, the ability to dissent suffers, and majorities gain the ability to entrench themselves through control of speech. And so free speech advocates, do have some concerns, myself included, about the extent of control that Facebook and Twitter have over public discourse. But there are a variety of paths you can take from there if you have that discomfort. And some have taken the path of trying to argue against their ability to moderate. They've argued that our commitment to free speech should be understood to prevent the platforms from kicking people off their platforms, or to prevent them from censoring certain speech. The other path is one that still tries to keep the First Amendment's commitment to keeping the government out of content moderation, out of deciding what can be said, and instead tries to attack a different source of the problem, which is the concentration of power that the platforms have. And so, what a lot of free speech advocates try to focus on, in part to avoid the First Amendment concerns that would arise if the government actually were to dictate what the social media platforms could do with their platforms, instead try to dictate the size of the platforms, to try to apply antitrust tools to the platforms, either to break them up or perhaps to disentangle them so that you'd break them up in different ways, but basically to inject competition in the social media market so that you had a variety of platforms rather than a few centralized ones. These are different approaches to, I think, a similar discomfort, but we're still trying to figure that out. And so far, the federal government hasn't acted. A couple of states have, actually. Florida has passed a law relating to content moderation by the platforms. Texas, I believe, has also now passed a law. Those are the first two states in the country to pass those laws. And they're both being litigated. They both were challenged almost immediately by a consortium of tech companies represented by NetChoice, in both of these cases. And we'll see how the courts end up ruling. The district court in Florida held that the law was unconstitutional, and the state has now appealed. And my recollection is that there is no ruling yet in Texas.
Yes, I will not comment on that because I could have a case like that, even though I don't. So I'll stay out of that. But let me just make the point that what creates this focus is the size and magnitude of these companies. I want to reiterate the point that Alex made. For example, the Southwest Jewish Congress. We do not have to host on the Southwest Jewish Congress platform any speech that is pro-Nazi. We have no obligation to do that whatsoever. And nobody would ever suggest that we had such an obligation because we don't. What makes it different is that Twitter, Facebook, Instagram, the like, have such a large profile in the world that these communications go out to multiple millions of people. And so that creates a new focus. One of our questions relates to how a person with a lot of money can communicate more effectively than somebody without a lot of money. I suggest to you that today in the internet world, you don't need a lot of money to communicate very widely. Hateful, incorrect speech. It happens all the time. Recently, there was a list of the top 10 anti-vaxxers. Some of those people you never heard of. And they have a very, very substantial internet profile. And it doesn't take a lot of money. It used to be that if you wanted to get a really big bang for your buck, you'd buy a big ad in the New York Times that cost you a lot of money. Now, that would get you a pittance of the audience that you would get compared to Twitter, Facebook, and the like. So what makes this different is the magnitude and scope of the audience of these social media platforms.
Can I add one point onto that, Judge, before we move on to the next point? So
yes.
I think that observation, I absolutely agree, and it kind of connects to the question that's in the Q&A in the chat right now, so I thought I might just bring it in.
Sure.
I apologize if I'm saying your name incorrectly, but Trouty in the chat asks whether, observes that the First Amendment protects assembly and wonders why people, users of the platforms, don't have a First Amendment right themselves to assemble on the platforms, and maybe they have a constitutional right, to assemble on the platforms. And in another context, we essentially recognize that, not in the context of the platforms, but in the context of what you might call common carriers. So telephone companies and the like. Courts have recognized the government's very broad authority to require companies like the telephone companies, which essentially control our communications infrastructure, right? You can't communicate with somebody unless you can communicate over the phone at a most basic level, at least at a distance. Obviously in person you can, but at a distance you can't unless you have access to the phone infrastructure. And as a result, courts have recognized that Congress has much greater regulatory authority to require those platforms, the telephone platforms, to host everybody, to provide service to everybody without regard to their viewpoints. And you might make a similar analogy. I mean, you could argue, and some people have, courts haven't yet ruled on this, you could argue that Congress has some authority to require essentially monopoly platforms to host everybody due to their significant control over communications infrastructure. And Florida has made this argument in its defense of its law that's now being litigated. My own sense is that it's a complicated argument, and I think it's unlikely to prevail, at least in the way that some people seem to want it to prevail. But it's an interesting argument and one that's worth thinking through.
Are there any exceptions to Section 230?
There are, and there was a recently enacted one for, I think it's for sex trafficking crimes. And so platforms now have some obligation with respect to sex trafficking crimes to, if they discover them taking place on the platform, to do something, otherwise become responsible for that speech.
So Alex, isn't it true though, that if Section 230 were repealed, that would probably be, I don't want to say the death knell of these social media platforms, but it would change them irreparably. I mean, I don't know the quantity of postings on these sites. It's in the, as my mother used to say when I was a kid, it's a number like a Googleplex. I mean, it's a really big number. I don't know what the number is, but it's really big. And there's no practical way that they can actually review everything that is being posted. So if they really have liability for something that is posted that is wrong and actionable, it's going to be a completely different world than we have now. And so people that are crying out for that change have been burned in one way or another by these social media platforms. So what could happen if Section 230 were repealed? What would the world look like for internet communications?
I think you're right. At the very least, it would look very, very different. The platforms would have every incentive to moderate aggressively, to do whatever they could using automated means, computers, to as quickly as possible algorithmically determine whether certain speech comes too close to the line that might generate liability for them, and if so, to keep it from existing on the platform, to prevent it from being posted. Now, you can imagine that working for certain categories of speech. Computers have gotten pretty good at detecting nudity, and maybe they would use nudity, for example, as a rough proxy for obscenity, or maybe as a rough proxy for non-consensual pornography, which is prohibited in a number of states. But it would be vastly over-inclusive. It would include art, for example, things that everybody recognizes as art.
You would never see the statue of David,
right,
on the internet again.
Right. And there are other categories of speech where it's hard to imagine how you could algorithmically determine, algorithmically identify liability generating speech, like defamation. It's hard to know unless you had an index of truth, which the platforms most assuredly do not. It's hard to know how you would algorithmically determine what is going to open.
Well, to use an example that we've talked about, if you plugged in the word Nazi, you would be getting rid of a lot of websites that would be opposed to Nazi ideology. I mean, it's just practically impossible. So can you be an advocate for free speech and advocate repeal of Section 230?
Well, I think you can. One interesting question that we spent some time thinking through, just because people have proposed to reform 230, is what work would the First Amendment do if 230 were repealed? Because the platforms would have an argument that the First Amendment would replace at least some of the protections that Section 230 provides. I think they'd have a reasonably strong argument that the First Amendment would protect them from liability, at the very least, unless they knew or had reason to know about a particular post. If they didn't know about or have reason to know about a particular post, then it'd be not so different from holding FedEx liable for any contraband that somebody sends through the system, that they have no reason to know about. There are differences, obviously, between FedEx and the platforms, and the important difference is that the platforms, moderate, speech, and so maybe people would argue that moderation means you're liable for absolutely everything in the way that some courts had before 230 was enacted. But I think speech on the platforms has changed so fundamentally since then that my guess is that courts would replace some of 230's protections. I definitely do not think they would replace all of them, but some of them with direct First Amendment protection. But I think you're right. Without Section 230, we wouldn't have nearly as open a public discourse online. I think it'd be just very hard to host speech like that. And some people might argue that's a good thing. Or they might argue what would replace the platforms is instead much smaller platforms over which it's reasonable to expect people to moderate. I spoke to one very prominent free speech advocate, is a guy named Bert Newborn. He used to be at the ACLU for many years. He's a law professor now at NYU. He's a well-known First Amendment scholar. And I asked him this exact question one time, and his answer was, If they're too big, then they shouldn't be that big. And if without 230 they can't survive, then they should be smaller platforms that can manage the liability that comes from running a speech and from running a distributor of speech, a distribution of speech. So that's another possibility. But who knows?
Was Section 230 a response to the internet platforms, or did it arise in a different context?
It arose in a different context. It was really a response to a couple of cases that came about in the early internet. There are two cases, one dealing with Prodigy, the internet provider Prodigy, and the other dealing with the internet provider CompuServe. And the courts, and I think one of them was maybe Prodigy versus Stratton Oakmont. I may be getting the case names wrong, but something like that. And they dealt with the liability that the early internet providers bore for the speech that went through their platforms. And in one line of cases, the courts gave the platform, relatively strong protection from liability, and in the other line of cases, platforms, the internet service providers were held to be liable if they edited, if they exercised some curatorial judgment, then they became liable for everything that went through their platforms. And Section 230 was an effort to, push back against that, to allow the platforms the space they needed to moderate without taking on all the liability that came from it.
All right, Alex, let me go back to something you alluded to earlier, and then we'll close this part of our program and take any additional questions that may show up on our Q&A or chat. Several of our Supreme Court justices have recently suggested that they would be open to rethinking a key decision that is really at the center of free speech law in the United States, and that's the court's decision in New York Times versus Sullivan. You alluded to that case, but tell us a little bit more, explain the arguments that the justices have recently been making, and tell us what your views are about it.
Yeah, so New York Times versus Sullivan, it was a case in the 1960s. It involved a suit against the New York Times alleging defamation based on an advertisement that was run about police in the South. And the rule that emerged from the case is that public figures who want to sue for defamation have to show that the defamatory statements made about them were made with what is called actual malice, which is a terrible phrase to use because in the law, it doesn't mean what it sounds like. It doesn't mean you're saying it maliciously. It means you're saying it with reckless disregard for the truth. So you haven't done your homework, or worse, you actually knew it was false, but you said it anyway. And it basically raised the bar for public officials to go after their alleged defamers, with the idea being that would create more space for public discussion of people who are important in public life, namely public figures, politicians and elected officials and the like. And some justices more recently have expressed misgivings about this ruling, saying it's not rooted in the text of the First Amendment. It's not rooted in historical practice under the First Amendment. And they argue it is responsible in part for the degradation in mainstream media reporting that they see in mainstream reporting today, because it insulates media from liability in all but the most egregious circumstances. It's very hard to win a defamation suit against a media organization if you're a public official, virtually impossible. And so some justices have questioned that. And there have been different responses to this. The general response by the media, and this is unsurprising, but also by free speech advocates more broadly, is to be pretty concerned, because New York Times versus Sullivan has been a cornerstone of free speech protection for reporting on public officials. Some people have been a little bit more intrigued by one narrower version of the critique. So New York Times versus Sullivan was about public officials, but it has also been extended to public figures. So these are, not public officials who have attained some notoriety for whatever reason. They have, come into the public limelight. They might be celebrities, or they might be well-known litigants. or they might just.
You're a public figure, Alex.
a very limited public figure.
I'm a public official and you're a public figure.
And so some courts have, the Supreme Court has extended New York Times versus Sullivan to public figures. And that means, for example, that if you are the parent of a child killed in the Sandy Hook shootings, and you sue Alex Jones, for example, arguing that that he has defamed you by claiming that you were a crisis actor and that your child was not in fact killed in the Sandy Hook shootings. That this extension of New York Times versus Sullivan means you may have a hard time recovering against Alex Jones unless you can show actual malice, even though you had no intention of becoming a public figure. You became a public figure in the most tragic and involuntary of circumstances because your child was involved in a shooting. And some people have criticized, in the narrower version of the critique, they've said, well, keep New York Times versus Sullivan, but get rid of this extension of it to public figures. Insulate criticism of public officials, but don't insulate criticism or defamation against public figures. And I think there's a little bit more interest in the First Amendment community for that critique. But it's an open debate. My guess is that there are not 5 votes on the Supreme Court to reverse New York Times versus Sullivan, but there are at least 2 justices who are very interested in it. And Justice Kagan hasn't. So the 2 who have weighed in so far are Justice Gorsuch and Justice Thomas. But Justice Kagan, when she was a law professor, wrote an article, and she used to write about the First Amendment. She wrote an article criticizing New York Times versus Sullivan, in part for this reason, saying it insulated them, it provided too much protection to defamatory speech. And so it's possible that she'd be open to considering narrowing New York Times versus Sullivan as well.
Well, that couldn't be done by Congress. That would have to be done by the court, wouldn't it?
That's right. That's right.
Just so everyone understands, this is the Supreme Court interpreting the Constitution, and Congress can't overrule the Supreme Court's interpretation of the Constitution. When the Supreme Court interprets a statute and Congress doesn't like that result, they can change the statute. But unless they amend the United States Constitution, which they don't have the votes to do, that is the law until the Supreme Court changes it. So, Alex, before we turn to questions, I'm going to just ask you one big sum up question, and you're not prepared for this, but go for it. What do you think is the state of free speech in the United States today? Have we gone too far? Have we gone not far enough to protect free speech? If the world changed as you'd like it to be, what would it be?
It's a really hard question. I have, I guess I would say, concerns in both directions. The big topic, especially if you're on a university campus like I am, is this question of cancel culture. Have we become intolerant of views we don't like? And I'm of 2 minds about this critique. On the one hand, I think that many people who complain about cancel culture point to instances that they think of as cancel culture that I think of as really counter speech. Because the First Amendment protects speech and it protects counter speech. And the idea behind the First Amendment is, instead of allowing the government to regulate speech, you let people regulate speech, and they regulate it by counter speech, by complaining, sometimes loudly and messily, about speech they don't like. And very often, what people are labeling as counter speech, I think of as counter speech. It's counter protest. And it's every bit as protected by the First Amendment as the speech that drew, the counter protest. And at the same time, there are a lot of things that I think of as better examples of cancel culture that most people who complain about cancel culture don't really identify as cancel culture. So an example would be the spate of laws that have now been enacted around the country, prohibiting the discussion of critical race theory in the classroom. That seems to me like a genuine effort to prevent conversation, to shut down conversation before it's allowed to occur, and not an effort, not just a form of counter speech. But many of the people who complain about counter speech cancel culture have not identified those sorts of laws as the problem. So I have that, I'm of that mind about some of the complaints about cancel culture. At the same time, I am troubled when people lose their jobs or their livelihood for genuine political disagreements. And there are plenty of instances where I think somebody's views have a direct effect on their ability to do their job. So for example, we entrust police with extraordinary authority to enforce our laws on the understanding that they'll do so equally and neutrally. And it seems to me relevant to whether they can do so, whether they have truly racist beliefs. But there are plenty of jobs where there isn't that connection, between somebody's views and their ability to do their job. And I'm troubled because at some point that reaction becomes coercive and not a genuine effort to engage. It's perfectly protected to fire somebody because of their jobs or to picket their, the small mom and pop shop on the corner. It's perfectly protected to picket them and to try to drive them out of business. But I worry that it does reflect an intolerance to disagreement and to opposing political views. And in that sense, I suppose you could say I do strongly value free speech, and I do strongly value our country's commitment to open dialogue, and do worry about it, even if what many people have identified as cancel culture is not what I would maybe think of as cancel culture. So that's my, on the one hand, on the other hand, quick take, but I think it's a hard question.
Well, I think if we had 2 hours or 10 hours or 200 hours, Alex, we wouldn't be able to solve the problems that we've alluded to tonight. We've got about 5 minutes. Let's try to pick up some of the questions that were in the Q&A or the chat. I'm going to combine a couple of those because I think we have covered some of them already. Let's talk about obscenity. You mentioned that during your introductory remarks that obscenity is not protected by the First Amendment. Child pornography is not protected by the First Amendment. There are a lot of exceptions like that. But the law of obscenity has not really changed much in recent times. Has it, Alex? I mean, this is a quite amorphous area of the law. It was pretty much said by the Supreme Court, you know it when you see it. There are evolving community standards. What looked obscene in one era might not be obscene in another. When my husband was a law clerk, there were many times when here at the federal courthouse, the judge and the law clerks were watching what was charged to be a pornographic film because they had to determine whether it was in fact obscene. I've been here for 21 years and I've never watched a movie like that. So I don't think there's all that much litigation going on now about the subject of obscenity. Is there?
Not that I know of. And many of the exceptions to the First Amendment have kind of atrophied in that way. Obscenity is, it appeals to the prurient interest, judged by community standards. And those standards, like you said, Judge, have changed so dramatically over the last few decades. The same is true of fighting words. You don't really see fighting words prosecutions anymore. They harken back to a time when, people thought it was just too much to go up to somebody else on the street and, yell some epithet in their face because that would just incite them to violence. And you don't really see those kinds of prosecutions either. And the main exceptions that I think are relevant to most conversations around free speech, are probably defamation, child pornography, which you unfortunately see so many prosecutions, and unfortunately just because there's so much child pornography to prosecute, but you see a lot of those prosecutions. But defamation is the most commonly invoked exception to the First Amendment.
So I'm going to ask you a general question. Jonathan Spiegel put it in the chat. I know what he's getting at, but I'm going to generalize his question a little, take you off the hook in terms of Yale. Can you just give a few comments about free speech in the college setting? There have been a whole lot of issues about people who have been coming to speak, organizations that have been having events, required apologies, disinviting speakers. Just give us a word about that before we sign off.
So I think this is actually kind of complicated, but there have been a lot of free speech controversies on campus, and I think they pit two opposing views against one another. So on one view, college is the time when young adults become adults, and we ought to expose them to the kind of full range of free speech and counter speech that living in the real world entails. And so we should, require them to tolerate. I see your light may have gone out there.
Yeah, excuse me, I'm in the federal building. After 8 o'clock, we have to pay our bill here. So somebody turned my lights off, so I can't do anything about it. So I will be speaking as if it's Halloween.
And so on that theory, we should require college students to tolerate all manner of speech because they're about to become adults. The other, kind of view is that the primary purpose of college is pedagogical, and the responsibility of the college, of a university, is to create an environment that is conducive to pedagogy, to learning. And a learning environment is very different than the real world. And you might want to keep out, for example, hateful views to make sure that people don't feel driven from public discourse in universities. And the reality is, I think these are both compelling arguments. I do think we should expect, college students to have, to learn some tolerance for opposing viewpoints and to figure out how to debate. I very clearly remember learning how to discuss really controversial topics in college, and I matured a lot in the course of learning how to do that. On the other hand, I do think it's true that expressions of certain kinds of hatred and harassment can make it hard to learn. They can, they distract students, and they can marginalize voices that historically have already been marginalized, and make that, free speech environment less equitable and less diverse. And I think that's a real cost too. And so I think at the end of the day, it's a balance. It's a balance of these two things. I don't think there's one answer to every controversy that arises. But have I sufficiently punted? Is that a?
I think so, Alex. Well, let me conclude by saying it's always a treat to be with you, Alex. I'm the president of your fan club.
Likewise, yes.
Ladies and gentlemen, I hope that you have enjoyed our discussion. You have a real treat this evening hearing from one of the leading free speech advocates in the United States. I'm very proud that Alex was one of my law clerks. So I want to thank all of you for joining the program. I want to thank the Southwest Jewish Congress for hosting it, and I wish you all a very pleasant evening. Good night.
Thanks so much.